Hello, my name is Dr. Jackalyn Rainosek, and I'm with DTP-Leadership Group. I have the privilege of Richard Wilson on with me today because he's the lawyer and he's going to help us understand this new tariff opinion we got from the Supreme Court. I want to say that I'm excited about this as a part of my podcast, Hot Topic Bold Talk, because I started these particular podcasts with Richard because I think we need to understand what's going on in the court system. Let's pay attention to what the district and federal courts are doing. Let's be able to pay attention to what the Supreme Court is. So today, I think this one particularly is a amazing case. And so I'm going to start and say, Richard, the first thing I want to say is I think this has really contributed to our American system as far as laws are concerned. I think it has significantly helped contain some of the president's rights to do tariffs. And I think it would be helpful for all of us to understand basically what the ruling says, and then I'll start asking you other questions about it, because it is literally 170 pages. So I look forward to what you have to say.
Understood, and thank you. And I'll start by saying that if we were to ask some of the Supreme Court justices, you know, whether or not this case is a big deal, I cannot deign to speak for them, but I would guess that many of them would say it is a simple case of statutory construction. We were asked whether or not the International Emergency Economic Powers Act, which is a particular law on the books, a federal law, gave a president, any president, the ability to impose tariffs under the language of that statute. And the 6-3 opinion was this particular statute does not give the president the power to do that. Now, having said that, I'll say going beyond the simple legal question that was answered, I agree with you about the ramifications. And I agree with you about the ramifications for this main reason. In the roughly 10 months to a year that it took for this case to be handed down, I think it's closer to 10 months. The case goes through the magnitude, and we're talking about billions in tariffs that have been collected by the government. And I don't mean 5 or 10 billion. I can't remember the number off the top of my head, but it's more in the hundreds of billions number. So the magnitude of this decision saying that it was improper for the government to collect those tariffs because the president did not have the power to impose them under that statute obviously has a massive economic effect. And we'll expand on that more as we discuss the different provisions, or not provisions, but the different opinions provided by the court in this particular case. As you pointed out, the totality of all of the opinions, majority, concurring, and dissent, are 170 pages. So, quite a lot of reading, even for those of us who might really dig the law.
Well, I can tell you one thing, it did enlighten me a lot. Thank you very much for highlighting the points I needed to read. I know that that Robert's opinion is short compared to the 170 pages. So, what could you do to begin to help us understand and name the court? I mean, name the case we're talking about. Please do that. But tell me what you see in the Roberts' opinion. Okay?
Okay, well, the name of the case is Learning Resources v. Trump. And Robert's opinion, you're right, is barely over 20 pages long. It's like 20 pages and one paragraph on page 21 of the 170 pages of opinions. And here's what's more. there are only 3 judges that joined in all 21 pages of Roberts' opinion. Those are Chief Justice Roberts, Justice Amy Coney Barrett, and Justice Neil Gorsuch. The 6 votes comes from Justices Kagan, Sotomayor, and Jackson, and their joining in the opinion was not as to the entire part. They did not join into part 2A2, which is what's called the major questions doctrine. And what Robert's opinion does um, is it goes into the language of the statute, and the question really being asked is the 2 words in the statute that the government was relying upon to say the president could impose these tariffs were the words, and let me get to it, regulate and importation. And here really is all you need to read from Robert's opinion to understand what the 6-3 majority holding is. Based on 2 words separated by 16 others in section 1702A1B of the Act, regulate an importation, the President asserts the independent power to impose tariffs on imports from any country of any product at any rate for any amount of time. Those words cannot bear such weight. So that is the opinion, that the words regulate and importation, separated by 16 other words in the statute, do not give the president the right to impose taxes. And Roberts points out in his opinion that a tariff, if that's what we want to call it, or a duty on imports is a tax. Roberts points out that a tariff has been considered a tax since the founding of our country. In fact, he points out the second act that Congress passed, there's a lot of historical analysis in his 20 plus pages, was the imposition on tariffs on the import of foreign goods. Before we had a federal income tax, that was in large part how the government raised money to sustain itself. They don't do things for free. And he points out that the power to tax is really important. And in order for that power to be granted by the statute, and this is where you really have disagreements amongst the judges, the statute has to be interpreted in a manner where that power is, I'll use the word clear. That's the word that is often used in the opinions, and the words regulate and importation, separated by 16 other words, Roberts says, is not a clear delegation of the congressional power to tax to the executive department. And there are several things that Roberts touches upon that I think, at least, are important in the decision. On page 2 of the opinion, Roberts has an entire paragraph where he points out that the president has issued several increases, reductions, and other modifications to the tariffs he imposed based upon an emergency. And
Right.
the stated emergency in the executive order imposing these tariffs was that we needed to stop the illegal importation of fentanyl into our country by imposing penalties on the nations where that fentanyl was being produced, and we needed to try to balance the trade deficit. So that's the emergencies he was relying upon to impose these taxes. And what Roberts points out is he started at 20% for China. He started at 10% for China. A couple of days later, he raised the rate to 20%. Then when China imposed tariffs, he imposed reciprocal tariffs, and by the end of it all, the total amount of tariffs on Chinese goods was 145% of their value. He goes into other changes that the president just made unilaterally. And I think that the frequent changes to the tariffs, really kind of willy-nilly, while ultimately this is an issue of interpreting words in the English language, um, the court will use certain cues to interpret those words, and the constant changes in the tariffs was certainly something that weighed heavy with several of the justices. Roberts mentions it on page 3 of his opinion, and when you get to the concurring opinion of Justice Gorsuch, he mentions it on page 39 of his concurring opinion. In fact, let me go to the language in Gorsuch's opinion because it's very clear that that was an issue for him. He says, before us, the president insists he may use IEEPA to equalize foreign and domestic duties or not. He may use it to negotiate with foreign countries or not. He may set tariffs at 1% or 1,000,000%. He may target one nation and one product or every nation and nearly every product. He may change his mind at any time for any reason. At least as I see it, history dating back to the near founding does not support the notion that presidents have enjoyed so much power. So the actions of the president in the handling of these tariffs, I believe, affected the decisions of several of the justices in the 6 justice majority. And Gorsuch comes right out and says it, that those actions had an effect on him, that seeing the amount of power that the president was trying to exercise through this statute, that is in part a reason why he doesn't believe the statute gives that amount of power to the president alone.
Let me ask some questions here because I think it's important. It seems like the emergency act he was trying to use, they're saying it does not justify that. So I want you to talk more about the emergency act and talking about that and describing it. But the other thing that I think that he is saying, there's no his, you know, well, let's go with the emergency act first because then I have two other questions about it. What they're saying in the Emergency Act, these words that are used in there are not sufficient for him to have had tariffs. I know personally, having taught government and sociology and a lot of stuff, that the Congress is the one that has the right to decide on tariffs or taxes. So I'd like for you to not only talk about the Emergency Act, but talk about where is the power to tax and do tariffs.
Well, the Emergency Act gave the president certain powers in relation to international trade. And the question is, did those powers include the power to tax? And the answer to that question was no. I'm not going to read the entire clause as
Oh,
Roberts
I know.
points out. You've got 2 words separated by 16 others. I don't want you to fall asleep on me. But in going ahead and skipping down to your second question about the power to tax, I'm once again holding up my little pocket constitution. And Article 1 delegates the powers that are enjoyed by the legislative branch, by Congress. And in particular, Article 1, Section 8. The very first clause of Section 8 reads, the Congress shall have power to lay and collect taxes, duties, imposts, and excises. That's the very first part of the first clause of Section 8 of Article 1. So that power has been vested in Congress. But over time, certain powers that Congress may enjoy, they have passed laws allowing the executive department under certain circumstances to exercise these powers. And it's not just specific to taxes. One of the cases, we've never really discussed it in detail, but I've mentioned in passing previously, is the so-called Chevron doctrine, which delegated to executive agencies, in particular the EPA, to make certain decisions to regulate and control pollution. And this Supreme Court decided a couple of years ago that the statute that was being relied upon did not clearly delegate that power to the executive branch or the EPA. So that's what it comes down to. Does the statute clearly do that? And I will point out, and Justice Kavanaugh does this in his dissent, there are numerous statutes that grant the president the ability to impose tariffs on the importation of foreign goods. Um, in fact, the very day that the president or that the opinion was handed down last Friday, just 7 days ago, the president held a press conference where he announced a 10% tariff on all imports under Section 122 of the Tariff Act of 1974. No, as Roberts points out in his opinion, and as several other justices point out in their concurring opinions, when the power to lay taxes has been vested in the executive branch, and the president is permitted to do this, in addition to the language being clear, saying that the president can impose tariffs, the language also places a great deal of limitations on what the president can do. For
Right.
instance, the 1974 Act, Section 122, sets a maximum tariff of 20% on the value of goods being imported, which is probably why Saturday the president woke up and said, well, it's not 10% anymore, it's 20%, because that's the maximum amount he can impose under that statute. And here's the other thing, those tariffs can only be in place for 150 days. There's a time limit on the imposition of tariffs under that statute. So the ability to tax, like many other congressional abilities, can be delegated, but ultimately this is where you get into the disagreements amongst the justices. The issue is, what does the language have to say in order to delegate this power to the executive branch, not just to this president, but to any president? Because what you'll find in Robert's opinion is a lot of what he relies upon, saying, look, we've done this before. He's relying upon cases that have been handed down in the past 4 years where the very same court, constituting the very same 9 justices, has set aside certain executive orders that were entered by President Biden prior to President Trump. One of those was Nebraska v. Biden, where President Biden tried to set aside student loans. And the court said, no, the statute you're relying on, the HEROES Act, doesn't clear, a majority of the court said it doesn't clearly give you the power to do that. So ultimately, that's what the decision really relies upon. I would argue that it's an English lesson. Okay, what do these words mean? And how certain are we that these words mean this or do not mean this? That's really what the entire opinion comes down to.
Well, and I think one of the things that I think is really good about this is Robert is saying the Supreme Court has already done this with Biden, so we're going to now do it with Trump. And we're going to take a position and we're going to make statements about what is taxable, what can we do with tariffs and things like that. I think one of the things that has been said in other write-ups about this case is that it has finally addressed the problem of Trump grabbing so much power as president and believing he can do it. And this does limit his power to be able to use tariffs. And I think one of the things I've noticed in the writings, because we have talked about a previous decision by the Supreme Court early in Trump's administration, that they gave him significant power. And there has been a question about that case. But now it looks like they are taking the language and doing what they have done several times with Biden or anyone else, and is now clarifying and saying, no, wait a minute. This is what your defined power is. It's not all these things that you've assumed.
Yeah,
Am I
and
being
what and I yeah, I apologize for interrupting. The one thing I will point out and that I want to make clear, to the extent I didn't in my discussion already, this decision does not take away from the president the power to impose tariffs, period.
right?
What the decision says is the president cannot impose tariffs under this particular statute, the IEEPA. No, I
Right.
agree with you that by taking away this power, I read the language from Justice Gorsuch's concurrence. I pointed out page 3 of the opinion by Chief Justice Roberts that it has severely limited the ability with which the president can impose tariffs. As I was saying, the 1974 Act he's relying on even now, as you and I are talking, has a 20% cap and a 150-day limit. So, can he impose tariffs? If the statute gives him the specific grant of that power, yes, he can, but he won't be able to impose the tariffs, as you put it, quite as broadly. The term I would use, he won't be able to change them quite as willy nilly as he has done under the IEEPA or was doing under that statute before the court held no, this statute does not give you the right to do this. I mean, they didn't say it's unconstitutional. What they said was, well, we're going to read the language of the statute, and the statute doesn't go as far as the government says it does.
And I think one of the things that we as Americans need to face is that he has done significant, well, I'll call it this because I'm the PhD on the group and I'm the one that talks about social dynamics. I think one of the things that's happened is he doesn't have the right to manipulate the world economy by his tariffs. There are limits, and that's what's happened. Now, one of the things that I
I,
think,
I, I
go
will
ahead.
point out, I will point out here, and this is not a legal issue. It was pointed out to me last week by one of my law partners that a report from the government issued last week reported that the trade deficit had in fact grown in the past year despite the tariffs being in place. No, ultimately, these opinions were largely written before that report was released, but I would say that if the emergency which allowed the imposition of tariffs on countries other than Mexico and China and Canada was an effort to balance the trade deficit, that the intended purpose of the tariffs failed miserably. Because
Right.
again, not only did we not reduce the trade deficit year over year, it has actually grown at a greater rate over the past year. And
Because of the
I am
tariffs.
not, you are a PhD, but I don't think either of us has a PhD in economics. But I'm going to rely on simple common sense. And that common sense is that in America, we consume at a far greater rate per capita than any other country in the world. So imposing tariffs isn't going to really reduce substantially the number of Barbies we buy or the number of French wines we import or whatever your particular foreign import of choice may be. If we want it, we're still going to import it. If we consume more than we produce, we're still going to need imports. So the stated emergency that this was attempting to treat, we're using the wrong medicine. We're using ivermectin rather than using, something that
Right.
actually works.
Well, and I think the thing that I've also read, and I think it's true, is Trump always tried to describe what these tariffs, tariffs were going to do. It was going to lower the deficit, and it has not done that at all. It's increased it. The other thing was that he was trying to control the fentanyl coming in, and the other thing is he was you haven't mentioned this, but he often argues that he's also trying to control the immigration process, and he ties in the immigration process, which has nothing to do with this. It's like he's trying to build a case that the immigration problem he sees is somehow related to having an emergency, so therefore he ought to be able to control Mexico, Canada, and China and other places to make certain these things don't happen.
Well,
I
yeah, and ultimately, like I said, I'm here to discuss the language of the statute with you. I would say that from a practical standpoint, if we're trying to combat the importation of fentanyl into the United States, I don't know that that's something that's legally being imported into the United States. So imposing tariffs on a drug that is being smuggled into the country
right.
in fruits or vegetables or through tunnels. Well, last I checked, Mexican cartels weren't declaring and paying tariffs on illegal drugs, so I'm not sure what the statute did for that. I'm not sure what the tariffs did to combat that either.
Well, and I don't think it did anything. I think it was a justification for what happened. Now, I want to go. I really like. I don't pronounce his name correctly, but I liked his opinion, Gorsuch. I thought his opinion added to what Roberts had always said. I thought Roberts, though, brought up an issue that I do not understand at all, where Kagan and the other two do not support it. So, what does it mean, major questions doctrine? I don't understand what that is.
Okay, well, and that's ultimately the disagreement. That's why there is at least one part of Robert's opinion, section 2A2, there are only three justices that join into it. And yeah, Gorsuch's opinion goes into it's really almost I like the analysis of it, but I would argue it's almost a childish rebuke of the three liberal justices that join into the 6-3 majority, as well as a childish rebuke of the three conservative justices that dissent, because Gorsuch's entire opinion focuses on exactly what you talked about, the major questions doctrine. And the idea behind the major questions doctrine, the simple statement of the law, or it's my simple statement, I'll leave it to constitutional scholars to tell me how wrong I am, but the idea is if Congress wants to delegate to the executive branch one of the powers vested to them under the Constitution that is deemed to be a major power, then they must do so in clear and explicit language. No, that is the major questions doctrine. Ultimately, the three justices that don't join into that section, the analysis under the major questions doctrine, those are Kagan, Sotomayor, and Jackson. What Kagan does is she points out, look, her argument is I think the major questions doctrine is a legal fiction. Ultimately, we're engaging in the interpretation of English language. Does this statute, can it reasonably be read to include the ability to impose a tax, to impose these tariffs on the import of foreign goods? And she goes through the language and makes it clear, and she relies a lot on what Justice Roberts says in his opinion in section 2A1, that and that is that she says given the separation, given the other powers specifically granted in this statute, I cannot reasonably read it to include the power to impose tariffs on imported goods. But she points out in her concurring opinion generally, and also in a footnote to her opinion, that look, this is not a major questions doctrine. This is a interpretation of the text, a textualism analysis. You know, the three justices, Kagan, Sotomayor, and Jackson, view the major questions doctrine as a legal fiction that the court will use to sometimes meddle into or wade into and say, no, this power hasn't been granted to the executive branch. Yes, it has. And they did that in the West Virginia case where they said the Chevron doctrine no longer applied. We don't care that these are experts at the EPA. We're not going to uh, we're not going to read the statute to have delegated this authority to the executive branch, and they do so in this case as well. They did so with regard to the student loan forgiveness case, calling it major questions. And what Kagan is really pointing out to Gorsuch is she says, look, it's almost I agree with your entire analysis, but I'm not going to call it the major questions doctrine. It
Okay.
is a simple statutory construction case. And that's really what it comes down to. And what is the distinction? I'm going to go into commercial litigation, things that I deal with on a regular basis. Um, Quite often we deal with contracts, we deal with language where um, someone will decide or a court will decide it's ambiguous. And what do we mean by ambiguous? We mean it's possible to read it more than one way, reasonably read it more than one way. That it can be read to include tariffs, it can be read to not include tariffs. Under the major questions doctrine, essentially what the court is saying is, well, even if both of these readings are reasonable, we think that this power that Congress has is important enough that it can't just be a reasonable reading of the statute. It has to be an unambiguous reading of the statute. There can
Okay.
be no question when we read the statute that this power is included in it. What Kagan is saying is, I'm not getting to that point because I don't even believe that the interpretation of the IEEPA that has been offered by the government is reasonable. We don't have an ambiguity here. The statute is unambiguous in not including the ability to impose tariffs on imports.
Right.
And in the language that they use, and it's interesting to me, none of the opinions relied on this, and it's probably because they were focusing on the language of statutes and the interpretation of other statutes. But the regulation language in the particular statute in question, the thing that I would point out is the first clause of Section 8 of the Constitution gives Congress the power to lay and collect taxes. Now, not 100 words further down in the Constitution, the third clause of Section 8 in Article 1 gives to Congress the power to regulate commerce with foreign nations, which would be the regulation of imports and exports. Clearly, when our founding fathers, or actually this came after the Declaration of Independence, but 12 years later, when the majority of our founding fathers crafted the Constitution that still governs us today, they saw regulating commerce as something entirely different from laying and collecting taxes, including tariffs. And I think that's important. But again, none of the justices thought enough of it to mention it specifically in their opinions. But yeah, what Gorsuch goes through is he talks about what do these other words in the statute allow you to do? Well, none of those come close to allowing you to tax. Has anyone else ever used this statute to impose tariffs on imports? No, the statute or its predecessor has been around for years, and nobody else has ever read it this way. These what I would call keys in interpretation. Justice Jackson, in her concurrence, says, there's something nobody else has mentioned. Let's look at the legislative history. Let's look at the discussions. Let's look at the committee hearings. And nowhere in those committee hearings did anyone ever say, hey, this statute's going to give the executive branch the power to impose tariffs on imports if it needs to do that to regulate international trade. Again, there are all these different cues, but ultimately, all of the different cues are being used to do one thing, in my opinion. That would be two. One thing, in my opinion. And that one thing is, does regulate importation mean the ability to tax imports? The dissent says, well, if the ability to regulate imports includes the ability to prohibit imports from certain countries, then certainly the lesser power to tax is included. So again, different ways of reading the same language. But what the majority is saying, what six justices said, is no. Everywhere else where the president is given the ability to lay taxes on imports, the language is really clear and really specific, and here it isn't. So that's a bridge we're not going to cross. Going back to Robert's language, that it's I would say it's a bridge too far, but the term he uses is that it can't bear the weight of the interpretation that the White House is trying to give to it. And at the end of the day, it really is high a high level English lesson where, as it were, or as it turns out to be, of our nine teachers, three of them disagree. Or I would say, yeah, three of them disagree on the meaning of the statute. But ultimately, the whole thing with the major questions doctrine is, even if these two interpretations of the statute are reasonable, we're going to say that in order for it to be read this way, it has to be unambiguous. It has to be more clear. So that is the layman's meaning of the major questions doctrine. And again, I tend to lean more with Justice Kagan. You
Do
can call
too.
it the major questions doctrine if you want, but to me, it's a simple matter of statutory interpretation. This major questions doctrine was not something that really began being mentioned, until my lifetime. And given that the country is 250 years old, that's a really short time frame for this to have existed, if it really exists at all.
And I think that's the reality. I don't think it existed. It exists, and I don't think it existed in the past. I think what we're getting here, though, is we're getting a very definitive statement about here's what the executive branch has the right to do and the president, and here's what they don't have the right to do. And I hope someday Congress will wake up and realize they have some powers that they could utilize in order to support the people in America and provide us with the kind of government that we truly need and not what's happening now. I want to ask you something
Yeah.
though. We hear about the court as being very, very conservative and that they have a traditional way of interpreting the Constitution. So that's what they were able to do with abortion and so many other things. That it wasn't that abortion, the word wasn't in there, so they had multiplicity of cases where they eliminated that right based on what their interpretations are. My question to you is, what is what is the objection of Jackson, Kagan, and Sotomayor is the objection they have to the major questions doctrine that some traditionalist judges seem to grab onto? Are they saying, number one, it doesn't exist, but number two, it doesn't even present what we need to address in this opinion? So that's why Kagan has been so clear about what she thinks the problem is. Now, I'm just
And
trying to understand so that my listeners can hopefully understand too.
Yeah, and what Kagan is saying is it doesn't exist. If it exists, again, it would be something that could arguably, or at least for three justices, it does address the issues presented with this statute. But what she's saying is it doesn't exist. Now, um, when I talked about Gorsuch really kind of being, calling out his colleagues for going in different directions on this particular judicial principle that the Supreme Court has, um, the without getting into it, in fact, she says, I'm not going to relitigate other decisions. We're only here today to decide this one issue. But there is certain language in those other opinions that these justices really kind of latched onto or focused on in those opinions that I would say differentiates their interpretations or their readings. In, say, Biden v. Nebraska, under the HEROES Act, it gave the executive branch, the Secretary of Education, the ability to do what the Secretary deems necessary to confront the emergency. So Kagan, Jackson, and Sotomayor saw that granting language deems necessary, what the department in its discretion, what the agency views as reasonable to deal with. It's the granting language of those statutes. These three justices are reading that granting language to be broader and to allow for a reasonable reading of those statutes to include the cancellation of 40 something billion dollars in student loan debt. That's really what I would say those justices see the difference as, and this is just my opinion, but the opinion is based upon, again, what those justices did say in those other cases. Kagan doesn't go into that, and now she's basically not going to. I'm going to use my own analogy. She's not going to follow Gorsuch down this rabbit hole. She
Right.
she says, I'm here to decide this one case, this interpretation under this one statute, and for these reasons, many of which are in Justice Roberts' opinion, I don't see this statute as having a reasonable reading that allows the president to impose these tariffs. So, to get back to your initial question and to answer it, I would say that what those three justices are saying, and the reason they didn't join in the 5 pages of the opinion by Roberts that discusses the major question doctrine, is they don't view that doctrine as existing. You guys can call it what you want, but it's not a real legal principle, and we're not going to adopt it today because we don't have to. And again, I talked about Roberts' opinion being 20 pages in a paragraph. The reality is the 6 judge majority is only about 15 to 16 pages of that opinion. So we've got 155 pages of just dicta, is what we call it legally, but a
You're
bunch
right.
of words that really have no meaning or no effect.
Well, but I think the key thing is that Kagan came down to what the real issue was about the act that the president was using to do all these wild tariffs that he did. And now we have a situation where she's saying, no, here's where it lasts. Here's what the administration can do. There's a limit on tariffs. It's 20%. There's a limit on the number of days they can have the tariff in effect. The other thing I know is, and I'll go back to this and say it a second time and then I'll move on. It has done nothing and has nothing to do with fentanyl. It has nothing to do with immigration. It has nothing to do with managing the import or export that happens in our country. So, what I want to do in these podcasts with your help, which I'm very grateful for, and the other ones I do, is to say, this is the truth, people. This is not what you're hearing. As people try to justify what they're doing. Now, I want to ask you something. What else do you think that we need to say so that everybody will understand exactly what has been presented in this case that is helpful to us as Americans who 78 million of them did not vote for Trump? So some of us sitting in America, we want to see the rule of law. So tell me, as a lawyer, how do you see that the rule of law has really been established in the various interpretations of six people? And you can only do two of them or something if you'd like.
Okay. Well, first off, with the rule of law, again, I'll go back to where I started. At the end of the day, all we've done is interpret a single statute and say it doesn't include the ability to impose these tariffs. Now, with regards to the broader scale of it, there are two things that I would mention. One of them is practical, but it has to do with the law. The judiciary, the third branch of government, um, the the president imposed these tariffs, not quite a year ago. And in that intervening time period, as several of the justices point out, the government has collected billions of dollars, and the tariffs ultimately were used as leverage to facilitate new trade deals with other countries.
Right.
Um, so, from a practical standpoint, the judiciary took 10 months to act and say, no, you can't do this under this statute. As we saw on Friday, the president took about 10 minutes to impose tariffs under another law that allows him to do so, even if it is not the same level of tariffs he was imposing under the IEEPA. He nonetheless imposed tariffs under an existing statute that is mentioned by Justice Kavanaugh in his dissent. There are other statutes that are mentioned by Kavanaugh in his dissent, and arguably, I would say the White House right now is probably starting with Kavanaugh's dissent to say, okay, what statutes can we rely upon to put more tariffs in place? And they're probably looking for other laws aside from those Kavanaugh
Right.
mentioned that they might be able to argue will allow them to impose tariffs. And each time they do this, I read the other day that apparently someone at the Cato Institute had offered the opinion that the tariffs Trump is imposing now under the 1974 Tariff Act are probably not legal. But as was pointed out, the Cato Institute, a liberal bastion of think tanks,
Right.
not. Um, for those who don't know any better, it's more on the conservative side.
Right
That might
on.
be an understatement. But one way or the other, the point that was being made is in order for someone to have the standing, the ability to file a lawsuit, they're going to have to first pay these tariffs that many people already think are illegal. And then they're going to have to go to the Court of International Trade again. And then you're going to have a decision on that again. And then you're going to have a direct appeal to the Supreme Court again. So 10 months to a year from now, which, mind you, unfortunately is lightning speed in the practice of law. Everything doesn't happen in an hour like it did on Ally McBeal. We might have a decision saying the other statute is not legal either. And this touches on something you and I discussed this privately before the decision came down. And I was telling you that I thought it would be a 7-2 or 6-3 decision saying that the statute doesn't allow tariffs. That was
Right.
based upon my readings of some of the questions the judges were asking. The one judge that I thought might go either way was, in fact, Justice Kavanaugh, or the one justice was Justice Kavanaugh. As I've mentioned in one of the prior podcasts, Kavanaugh seems to take a practical approach and look at what are the
Mhm.
impacts of my decisions going to be. And that seems to weigh heavily on him in the three justice dissent. On page 6 of the dissent, he points out that the government may be required to refund billions of dollars
Right.
to importers who paid the tariffs, even though some importers may have already passed those costs on to the consumers like you and me. And the language he uses is that this refund process is likely to be a, quote, mess. And he uses the same language, I want to say, later on in his opinion, page 60 something of his opinion, he again refers to the upcoming refund process as a mess. And I think that one of the things that weighs on him is he really does take a practical approach to what are the ramifications, what is the effect of this. And I think that also creeps through, this is just my opinion, in the fact that he's giving other statutes that the executive branch can nonetheless rely on to impose these tariffs. It's almost as if he's saying, why are we even going to do this? Because the White House can still impose tariffs under these other laws. And I'm not even sure that the government is facilitated to um, effectively and appropriately handle these refunds, given that the importers have already recouped their money by passing it on to the distributors that they were selling the products to, who ultimately passed on that very cost to you and I. Coffee isn't $5.99 a pound anymore when you're getting it from Colombia. It costs a little more now. And it that again, we're delving into economics in discussing that practical effect, and that would be the one criticism I would have of Kavanaugh, Justice Kavanaugh joining in the dissent is if you're letting the practicalities of the decision weigh on this,
I don't,
I'm not
yeah.
sure that's something you should be engaging in when you're supposed to be simply construing the text of the statute. No, he then goes on to try to justify why this particular text uh, allows tariffs, as I mentioned to you previously. Well, if they can ban imports, then certainly the lesser power of imposing a tax on those imports should be included. I tend to disagree with that, but again, ultimately, what it comes down to is the practical effect of this ruling, and that's going to be the big thing that I think most people will be talking about and focusing on now. Here's another thing with the law. It's called ex post facto, after the fact. The White House cannot go back now and say, well, in the past 10 months, we really meant to impose these tariffs under this law, so we don't have to refund any money. We talked about that with regards to um, the indictments that were handed down against James
Right.
Comey. That you can't go back and rely upon another statutory power. That's not the power that was used to make the initial appointment.
Right.
So you can't go back and say, no, 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 this is what we mean now. And it'll be the same way with the statutes here. Even if they can do it going forward, there's still the issue with the refunds and to whom the refunds are going to be paid. And ultimately, what it comes down to is it's going to be a windfall for the importers that have already passed this cost on to you and I. Um, that's really how it's I think it's going to work out is they've already absorbed the cost and passed it on down the line. So now they're going to get the benefit of getting the money back because it was collected from them illegally. And that's again on the legal end of it, I'm touching on the practical effect, but the legal end of it. But in that regard, I'll point out another thing because I was indicating I didn't agree with Kavanaugh's view of the statute. One of the other things that Kavanaugh says in the dissent is, well, we shouldn't apply the major questions doctrine, this, requiring the clear and specific language when we're dealing with international law, because the ability to enter treaties, these international powers, many of these are vested with the executive department. But I think the language that I'm pointing out that I read from page 6 ultimately shows that this is the imposition of the tax was not an international power. It was a national power, because despite what the White House may say about who was ultimately paying these tariffs, it was not the manufacturers and producers in China or Mexico or Canada or Malaysia. It was ultimately when the importer received the goods, the importer then had to declare where the goods were from, what the value of the goods were, and the importer, a U.S. company, then had to pay these tariffs. So the argument that this is international, I'm I find that argument difficult to swallow, given that the tax was
I don't think
imposed
it's right.
on a domestic importer for bringing the goods in internationally. Might it have had an effect on overseas producers? Maybe, but ultimately the question is who is paying the tax, and the who in this part is not the foreign manufacturer, it is the U.S. importer.
And it's the U.S. importer, then you and I pay the ultimate tax that these tariffs have done. I want to
Yeah, it
go,
doesn't show up on the bill like a sales tax, but like I said, if people want to wonder why coffee costs so much more for the past year than it did in 2024, I'm pretty sure it isn't a massive increase in the wages paid to the men and women that are picking the coffee beans. It's a reflection of the tariffs on those coffees that were being imposed on whatever country the beans are being imported from.
well, and the thing that I think is really important to realize is that um, which was it, Costco or Sam's decided that they were going to put how much the tariff was, and then they
It was
were
Sam's slash Walmart.
right, and they were going to put out what it really cost. And of course, they got reprimanded extensively, and there were threats, and there were all kinds of things. I think one of the things I happen to have fallen and broke 6 ribs on the right hand side. And so I have been using the cloud, KLOUD, from Centerplex. And Centerplex is in Liechtenstein. So I can tell you right now that when I talk to my customers in America and they ask me about the cost of it, I say to them, and part of that is a tariff, and they look at me with great dismay that it may be $350, it may be $689, and they say that's the tariff I'm going to be paying because of what has been done. So I do have an opportunity now to say to people, wake up what these tariffs have done. And it's been an amazing kind of thing for me to talk with people, no matter what political party they're in, and go, I didn't realize that. Now
Yeah,
I
and
want to do
ultimately you're
something
small enough that unlike Walmart, the weight of the government is not going to be threatened upon you.
right. Right. Well, they
No,
may after they hear my podcast, but here's what I want to do. Richard, I do want to I am going to offer to my listeners, as I always do, references. So I'm going to give them several references. But one of the things that I think is really important, I'm going to give a very short one from Forbes because they talk about what Kagan's talking about, the mess it's going to take to straighten out paying these things back. But I want to go to one of the articles. I have two others besides besides the one I just mentioned. I want to go to an article in the New York Times, and I want to go to a specific article by David French because the title of his article is this the most important Supreme Court case of this century? Now I know that's what he's saying, but what I like about his paper is he brings up 3 points that I think people are totally unaware of, which has been the impact. So I'm trying to do something and say, okay, Kavanaugh, if you can do this, I can do this, and I can show you as an American what the impact has been. His first point, Richard, is the court blocked a monumental presidential power grab, one so big and so bold that it threatened the foundation of our constitutional system. The Chief Justice's opinion hung on a legal principle called major question doctrine, the same doctrine that was used repeatedly to block Biden's administration concerning regulations and orders. And then it goes into what you've done an extensive thing with Gorsuch. But it's stating you cannot use the words regulate and importation. They aren't precise enough to grant the presidential extraordinary powers that they did. So I'm building a case through French and saying he supports of a lot of the things that we've talked about today. The second thing, though, he brings out is he said it's the most important aspect of a court's decision is that it may help restore faith in how courts make decisions. The crisis in American democracy is simply a product of Trump's administration overreach. It is also a product of deep public cynicism about the government. Now, Trump benefited from the cynicism about the government. But as a result, millions of people wonder, do principles really matter? Is it all of politics merely a matter of gaming and wielding power, supporting your friends and crushing your enemies? The tariff decision is a reminder that principles do still matter, that at least one branch of the government is not enthralled and is controlled by the president, and that we can rely on reason and precedent to decide cases rather than simply counting Republicans and Democratic appointees. And he's confronting the Congress and what they have not done. The third point that French does, and I don't think this is at all clear in any of the legal opinions, he says the third is less obvious is the court's decision helps preserve the republic by limiting opportunities for corruption. B, by assuming vast powers of taxation, Trump made himself the focal point for an enormous amount of lobbying and trading favors. In January, for example, Politico reported that 20 largest lobbying firms raked in nearly $824 million in revenue in the first year of Trump's second term, a sharp increase from $595 million in Biden's last year. The administration has sent a message loudly and clearly: almost anything is for sale at the right price. And the ProPublica reports last April, politically connected people and companies were already benefiting from what appeared to be targeted relief from Trump's tariffs. The reason I'm doing this, and I'm going to provide these documents as well, or the references, is because I think we go far beyond the legal interpretations that we have here. And we have to stop denying when these things happen that something much larger is occurring than just an action by the president or a lack of action by the Congress. So now that's now it's your turn, and you and I have different ways of viewing things. So if you would like to comment on anything I've said, I look forward to it because we've been friends for years. We have been in different parties at various times, and we tend to have the same value structure, which is honesty and a belief in integrity. So please, if you have any comments, and I'll listen to those and we'll have a short discussion, and then we're going to end this podcast.
Well, I'll weigh in on this, and this will probably be a good place to end it. I'll have three things in response to what you've pointed out, in particular with French. One, I'm going to go back to it and say the case does not hang on the major questions doctrine. You only had three judges in the
Right.
majority deciding it on that. To me, the case hangs on a simple issue of English language and statutory construction. Two, whatever other effects French touches upon, those would be side effects of this statutory interpretation matter. I agree that perhaps by seeing three conservative justices make up the majority with the three perceived
Right.
liberal justices on the court, perhaps that will help with people's opinions of the courts for the time being. For how long, we will see. But the third thing, and this is where I'm really going to bring everybody down with the what now, is in relation to all of the lobbying and the favor trading and everything else. We've already touched upon this. There are other statutes that are still going to allow the president to impose tariffs. And even if he's doing it improperly, and it is not something that's permitted under the statute, it's going to be 10 months to a year on the
Right.
fast track before the court will weigh in and say, no, you can't do this. The other problem, and this goes back to the old Andrew Jackson phrase, well, that's what they've said, now let them act on it. The judiciary branch, unfortunately, doesn't have any enforcement powers. The
Right.
idea behind the framers was that the judiciary branch would weigh in and tell us what we could do, and we would then do it. And that is ultimately the problem is given the glacial pace at which the judiciary moves and the rapid fire pace at which the executive branch moves, regardless of who's in control, it's going to take time to undo these things. And I think that once again, it's going to be a situation of playing whack-a-mole. Well, the White House can't use IEEPA, so now they're using the Tariff Act of 1974. Now they're using some other tariff act. Now they're using some other statute regarding international trade that they're arguing allows them to impose tariffs. It I'm not sure long term what the ramifications will be beyond the government having to sort out how much needs to be refunded and where's the money going, unfortunately.
And I want to tell you, I support what all you're saying. And this is the one thing I'm going to say. In the November elections, we have the right to make decisions about the people that are representing us. And we have the right to speak out and say, I don't support the corruption. I don't care whether we support the major question doctrine or not, whatever it is. I just know that I am going to support the rule of law. And when we have a opinion like Kagan and also Roberts, and six judges support it, then we have some kind of movement in the right direction. Now, I think the changes, though, are going to be very slow, and it's going to take a lot of time, and it's going to take a lot of us supporting our Constitution, believing in the rule of law, and believing that in our right to vote, we have the right to have a voice and speak out against what we do not like and support what meets our values. So that's the way I'm going to end it. Um, and I appreciate all the detail, all the work you do. And please know it takes Richard a lot of time to read all this and really get expert in presenting it to you. And not only that, then he has to highlight things for me so I can have some understanding and then I go seek out. So we are doing our best that we can to provide as many views as possible. So I hope you've enjoyed our podcast today. I hope you will think about what we're saying and start paying attention to what the courts are doing, as well as what the executive branch is doing, and then the lack of action in the Congress. So I hope we will see a difference because I believe in the balance of power, and I think you believe that too. So thanks much, Richard, and I'm going
Sure
to
thing.
end
You're
the
welcome.
podcast.